Why can't you disinherit your spouse in a will? Firstly, you can disinherit a spouse in a will. If a spouse legally, contractually agrees to be disinherited, they can and likely will be. However, if they refuse, then you have to pursue other options and negotiations. The laws vary from state to state, but in a community property state like California, your spouse will have a legal right to one half of the estate assets acquired during marriage, which is otherwise known as community property. In common law states, an individual may choose to disinherit a spouse in their will. However, the surviving spouse may have a right to seek their rightful inheritance by filing a right of election. Generally, they will be legally entitled to about 1/3 to 1/2 of the estate assets acquired during the marriage, again depending on the state law. Where there is no community property right and no right of election, a spouse is free to disinherit their spouse in their trust or will. Can I contest or dispute a disinheritance? Yes. In most states, a spouse who has not agreed to be disinherited can take legal action against a decedent who disinherited them in a will or trust. Also, disinherited children similarly can take legal action, especially if they can show that a decedent disinherited them due to undue influence, duress, or lack of mental capacity.